Now we're going to talk about European Union readmission policy and human rights implications. If I may have your attention, just to introduce the panel. We're going to be talking here of this second round of this panel co-hosted by the Human Rights Subcommittee within the Foreign Affairs Committee, chaired here by our colleague Mrs. Lochbihler, and LIBE Committee on EU readmission policy as a key element of EU migration and asylum policy as a whole. We are to reinforce the EU migration and asylum policy in this regard. We may not forget that development of this area of European Union level will only be achieved through a balanced and comprehensive approach to migration policies. The European Union readmission policy is also embedded on the overall external relations policy of the European Union. Readmission agreements are a central part of the European Union cooperation with third countries, managing migration and asylum. That involves the European Commission, but ever since the Lisbon Treaty entered into force, it involves most effectively the European Parliament. So let's have in mind that the European Parliament is empowered to provide consent or not as regards readmission agreements. Article 218 of the Treaty of Functioning of the European Union makes sure that we are the final word when it comes to signing agreements regarding readmission within the migration policy. Back in 2010, during the negotiations of the first readmission agreement, there was a Commission declaration added to the European Parliament resolution on the matter as an annex, stating that the European Parliament shall be regularly informed as to the conclusion of readmission agreements. Under this framework, the European Commission, different levels, will be attending LIBE Committee meetings, and nevertheless, in order to reinforce this European Parliament's exercise of its power to give consent or not to readmission agreements, this exercise of cooperation is to be set into practice in a very effective manner. We believe that this involvement of the European Parliament will provide necessary scrutiny and no doubt will have consequences in improving the contents, the substance of the readmission policy as a whole. That is why we should be debating for the next hour how can we contribute most effectively to ensure added value from the European Parliament side to the relaunching of the European Union readmission policy as a component element of the successor, the potential or eventual successor of the Stockholm programme for the coming 5 years in the coming term of the European Parliament. So we give way to this discussion by leaving the floor in the first place to Mr. Jean-Pierre Cassarino as Director of the Return, Migration and Development Platform of the University Institute in Florence. There you go. The floor is yours.
Merci beaucoup, Monsieur Aguilar. Je parlerai en français, si ça ne vous parle. D'accord. Tout d'abord, Mesdames et Messieurs, bonjour. C'est pour moi un grand honneur de vous adresser la parole et je remercie les organisateurs de m'avoir invité. Ma brève intervention portera en fait sur le système européen de réadmission et ses implications en matière de respect des droits humains. Alors parler d'un système me paraît tout à fait pertinent et adéquat. Tout d'abord pour évoquer la multitude d'accords qui ont été conclus d'une part par les États membres de l'Union européenne et ensuite par l'Union elle-même. Naturellement, je n'aurai pas le temps en 10 minutes d'évoquer les facteurs qui ont consolidé ce système en expansion, comprenant des acteurs étatiques aux intérêts forts divergents. Toutefois, je préfère me concentrer en fait sur les conséquences en matière de respect des droits fondamentaux. Comme vous le savez, comme cela a été dit par M. Aguilar, depuis en fait l'entrée en vigueur du traité d'Amsterdam, l'Union donc a une compétence en matière de réadmission. Et le traité de Lisbonne, 10 ans plus tard, a en effet clarifié la compétence partagée entre l'Union et les États membres en matière de réadmission. Bien évidemment, l'existence d'une compétence partagée entre l'Union et ses États membres ne devrait pas poser de problème si celle-ci est régie par le principe de coopération loyale, principe clairement énoncé dans l'article 4 du traité de l'Union européenne. Et ce principe implique nécessairement la mise en place de mécanismes de contrôle à même d'assurer la réalisation des objectifs de l'Union et le respect des valeurs sur lesquelles elle se fonde, dont, entre autres, le respect des droits de l'homme, le respect des droits des personnes appartenant à des minorités et le respect de la dignité humaine. Naturellement, là, je me réfère à quelques articles, l'article 2, l'article 6 du traité sur l'Union européenne. Cela implique également l'existence d'un certain degré de convergence entre les priorités des États membres et celles de l'Union. C'est un point sur lequel je reviendrai plus tard très brièvement en fait. En ce qui concerne les mécanismes de contrôle, tout d'abord, je souhaite insister sur le fait que les obligations internationales en matière de respect des droits de l'homme et leur application concrète relèvent de la responsabilité des États membres dans le cadre des protocoles d'application bilatéraux conclus entre ces derniers et chaque pays tiers impliqué dans le cadre d'un accord européen de réadmission. Alors ces protocoles, une fois établis, en fait, sont communiqués au comité mixte de réadmission. Naturellement, on peut penser que le comité mixte de réadmission constitue, si vous voulez, en fait, le lieu où l'application bilatérale des accords européens de réadmission serait, en quelque sorte, passée au crible. Or, sa fonction pour l'heure consiste principalement à traiter des questions d'ordre technique concernant l'application même de l'accord. Cela dit, et selon moi, le comité mixte de réadmission doit s'équiper d'un dispositif additionnel impliquant des acteurs à même d'informer sur les conditions et réalités concrètes auxquelles sont confrontées les personnes réadmises vers un pays tiers. C'est un comité qui aurait naturellement pour fonction d'informer sur les modalités selon lesquelles ces personnes sont bien évidemment réadmises et également les problèmes qu'ils soulèvent concrètement. Ce dispositif est d'autant plus nécessaire que l'Union européenne a conclu des accords européens de réadmission avec des pays qui ne sont pas signataires de la Convention de Genève datée de 1951 sur la protection des réfugiés. Je pense plus particulièrement au cas du Pakistan, avec naturellement des conséquences sur le respect des personnes expulsées vers le Pakistan, mais également en transit par le Pakistan pour se diriger vers l'Afghanistan. On en parlera, si vous voulez, durant le débat. L'Union européenne a également conclu des accords avec des pays tiers qui sont signataires de cette convention, mais qui n'ont pas un système d'asile efficient. Et là, le cas de l'Ukraine est un des cas emblématiques. Je ne peux pas tous les citer. D'ailleurs, récemment, un rapport a été remis par le HCR, en l'occurrence, pour dénoncer justement, disons, le danger en fait des procédures de réadmission vers l'Ukraine. Également, des accords ont été conclus vers des pays qui en fait ne sont pas considérés comme des pays tiers sûrs par le HCR. Encore une fois, là, je parle du cas de la Serbie. Des accords ont été conclus avec des pays tiers où le respect des droits des minorités ethniques et des apatrides est fort problématique, le cas du Kosovo. Des accords ont été conclus avec des pays tiers susceptibles de renvoyer des ressortissants d'autres pays tiers réadmis sur leur territoire vers leur pays de provenance. Je fais ici en fait référence à l'effet domino, mais aussi au cas des pays tiers dont en fait la loi sanctionne par l'emprisonnement le franchissement irrégulier des frontières. Je pense entre autres au cas du Maroc avec lequel un accord européen de réadmission est en cours de négociation et certainement de finalité en fait. Donc les problèmes, si vous voulez, sont fort nombreux et leur acuité plaide en faveur d'un dispositif allant bien au-delà du souci d'opérabilité et de flexibilité qui, à l'heure actuelle, continue d'orienter l'application des accords. D'autant plus que la Charte des droits fondamentaux de l'Union européenne a, depuis l'entrée en vigueur du traité de Lisbonne, la même valeur que les traités. J'ajouterai également qu'en vertu de l'article 17 du traité sur l'Union européenne, la Commission a pour mission de veiller en toute indépendance à l'application des traités. Par conséquent, l'accomplissement de sa mission sera fonction de la mise en place d'un dispositif d'avertissement précoce et de surveillance. Ce dispositif ou système de veille dont je viens de vous parler permettrait non plus d'invoquer, mais plutôt de justifier, en fait, l'application d'un accord européen de réadmission susceptible d'entraîner la violation des droits fondamentaux, ce dont nous parlait tout à l'heure M. Aguilar, et puis également, naturellement, de justifier aussi les critères utilisés afin d'identifier les pays tiers avec lesquels des accords européens de réadmission sont susceptibles d'être négociés à l'avenir. Donc, je suis en même temps conscient que, d'une certaine manière, ces critères ont déjà été établis en 2002. Mais ils répondaient à une période très spécifique, disons, de l'histoire de la construction européenne. Aujourd'hui, après l'adoption du traité de Lisbonne, suite également à l'insertion, disons, de la charte des droits fondamentaux dans les traités, je pense qu'il est nécessaire de redéfinir naturellement ces critères. Passons brièvement à cette deuxième question dont je vous ai parlé tout à l'heure, concernant la convergence des priorités, autre condition sine qua non à la coopération loyale entre les États membres et l'Union. Comme vous le savez, à l'échelle bilatérale, les États coopèrent depuis toujours en matière de réadmission. Bien avant la Commission, certains d'entre eux avaient intégré leur mode de coopération bilatérale dans le cadre d'une approche que l'on qualifierait aujourd'hui de globale, conscient du fait que la coopération bilatérale en matière de réadmission se base sur des obligations certes réciproques, mais fort déséquilibrées dans les faits. Et plusieurs États ont également acquis le fait que des pressions politiques ou diplomatiques, aussi fortes soient-elles, ne peuvent suffire, en fait, à convaincre un pays tiers à coopérer de manière optimale en matière de réadmission. Ils ont également acquis le fait que ces pressions peuvent mettre en péril des relations bilatérales consolidées en matière de lutte contre le terrorisme international, en matière de coopération policière, de relations commerciales, de contrôle des frontières, de sécurité énergétique. Donc de mettre en péril, si vous voulez, un cadre de partenariat bilatéral beaucoup plus élargi. Alors, lorsque je parle d'un cadre d'interaction bilatérale plus élargi, je souhaite mettre en évidence le fait que la réadmission, à l'échelle bilatérale, s'intègre dans un espace où les affaires intérieures, les affaires étrangères, les relations commerciales s'entremêlent étroitement. Si la coopération bilatérale en matière de réadmission constitue certes un problème clé à l'échelle bilatérale, son importance relative est toujours évaluée par les États membres en fonction d'autres questions stratégiques, voire beaucoup plus vitales. Alors, je n'ai pas le temps de développer cet aspect dont nous pourrons parler, si vous voulez, au cours du débat. Toutefois, ce cadre d'interaction bilatérale contraste fortement, selon moi, avec celui que l'Union européenne a développé depuis le traité d'Amsterdam, puisqu'il existe de nombreux domaines de coopération conditionnés, en fait, par la coopération dite efficace en matière de réadmission, et que cette conditionnalité à l'échelle européenne est quasiment omniprésente. Donc il y a une forte centralité de la réadmission dans le cadre des relations Union européenne-pays tiers, en quelque sorte. Un autre aspect également qui est propre à l'Union européenne est que la DG Affaires intérieures domine fortement le cadre d'interaction avec les pays tiers, alors que, selon moi, le service européen pour l'action extérieure aurait un rôle de premier plan à jouer afin de mieux décomposer l'approche globale des migrations que l'Union européenne tente de promouvoir, si naturellement le service européen d'action extérieure réussit à faire valoir son point de vue. La coopération en matière de réadmission continue donc d'être guidée, si vous voulez, par la logique de la rapidité, de l'efficacité, de la flexibilité qui, inévitablement, est peu compatible avec le respect des normes internationales en matière des droits humains. Accroître les mesures de contrôle des frontières et de la mobilité comporte un danger majeur dans certains pays tiers, celui de renforcer l'arbitraire, voire de le rendre acceptable par le mal nécessaire. Et il y aurait des exemples à traiter par ce biais-là. Alors cela s'opère, si vous voulez, par un déni subtil où l'opérabilité et la flexibilité l'emportent sur le respect effectif des normes internationales relatives aux droits des migrants, des demandeurs d'asile et des réfugiés. Je ne sais pas dans quelle mesure, en fait, le binôme DG Affaires intérieures et Service européen pour l'action extérieure pourra en quelque sorte désenclaver la question de la réadmission et selon quelle modalité politique. En revanche, Je sais que les conséquences des accords de réadmission, qu'ils soient européens ou conclus à l'échelle bilatérale, font l'objet d'une attention croissante de la part des organisations et associations de défense des droits humains à l'échelle internationale et nationale, en Europe tout comme dans les pays tiers. Par exemple, cette vigilance est grandissante dans les pays d'Afrique du Nord qui, comme vous le savez depuis le printemps arabe, sont confrontés en fait à des attentes sans précédent en matière de justice sociale, de développement, de liberté de mouvement et de dignité humaine. Bien évidemment, ces attentes exposent en premier lieu les décideurs de ces pays tiers, certes. En même temps, ces attentes exposent aussi l'Union devant des défis majeurs auxquels une politique globale en matière de relations extérieures conditionnée par la coopération efficace en matière de réadmission ne pourra répondre effectivement. Pour conclure, je souhaite simplement dire qu'il y a aujourd'hui naturellement un critère devant lequel l'Union européenne est confrontée, qui est celui en fait de la valeur ajoutée, et ce depuis en fait l'entrée en vigueur du traité d'Amsterdam. Je souhaite dire, sans vouloir paraître peut-être trop comment dirais-je, trop idéaliste, mais je crois que la plus solide et crédible valeur ajoutée que puisse apporter l'Union européenne dans le cadre de ses relations extérieures avec les pays tiers et en matière de réadmission réside précisément dans le contrôle du respect des droits fondamentaux. Il est clair que le rôle renforcé du Parlement européen sera crucial en la matière, tout comme également sera crucial celui du service européen pour l'action extérieure. Je considère qu'il a également un rôle clé en la matière à jouer. Voilà, je vous remercie de votre attention.
Nous vous remercions, professeur Cassarino, représentant de l'Institut Universitaire Européen à Florence. Et maintenant, nous passons la parole à Madame Marina Schramm, experte de l'Organisation Internationale de Migration. Marina Schramm, you got the floor.
I'm here. Thank you very much. First of all, and on behalf of the International Organization for Migration, I would like to thank you for inviting us to participate or contribute to this debate. Whilst IOM, our organization, is not involved in forced return and not thus involved in readmission as such, IOM has been supporting third countries that concluded readmission agreements with the European Union through capacity building in the context of readmission, including on human rights, and we have also been looking into monitoring the situation of readmitted individuals after their readmission. But first of all, I would like to share some general remarks regarding readmission and human rights. And I think this was mentioned by Mr. Cassarino as well. Readmission as such is a tool or a procedure to implement a return or removal decision. And as such, it should not have a direct impact on human rights. And in general, the signature of a European of a readmission agreement should take into account the situation in the country of return. And thus, in case of concerns, there should be no readmission. However, on the other hand, readmission agreements make the removal procedure more efficient, faster, and it is thus very important also to look into ensuring that the simplicity of the procedure does not overtake over the need to grant individuals full access to procedures and rights before readmission. And this gets even more relevant when we consider that some countries receiving countries, third countries, might consider that the situation of the readmitted individual has been fully assessed in the European Union member state before return, and that thus no more access to rights or procedures shall be granted after readmission. Now I would like to pass on to monitoring. There are two possible scopes of monitoring readmission. One scope would be the procedures. How efficient is it? How effective is it? But this role is mainly covered by the joint readmission committees. On the other hand, there is the treatment of individuals, the people who are readmitted. What happens before, during, and after readmission? What IOM is looking into and has been focusing on is what happens after readmission. And there are several things to look at. First, what happens immediately after readmission? How are people met when they come back to the country of home or transit? But also in the long term, how sustainable is the return of the individuals? What chances do they have to either reintegrate or to integrate? And there are two different categories of individuals where I would like to go into a little bit more details on what needs to be looked at. First of all, own nationals. And this is more relevant for certain readmission agreements than for others. For example, Georgia, for example, Pakistan, for example, Sri Lanka. And here we need to see that upon return, people have access to immediate rights and get documents granted, get property rights granted, parental rights, whatever rights or whatever documentation they might have lost whilst being away. But then it's also important to look into the long term. How sustainable will the return be? Will the person have a chance to rebuild their life after readmission? And there it is very important to cooperate with local authorities and ensure that they are aware of particular issues people might face after their readmission. The second group is third country nationals, and monitoring their situation is of course more relevant when we look into typical transit countries such as, for example, Ukraine that was mentioned before. Of course, one concern is to ensure access to asylum, but I believe my colleague from ECRO will talk about this in more detail. But then there are a few other concerns. I think the main, when we speak about readmission, is to, again, look into the access to a sustainable situation. Individuals should be readmitted only to a third country if return to their own country is not possible. So we need to see what will happen in the third country, the transit country. Do they have access to sustainable integration, to voluntary return, to procedures that might grant them temporary residence, and any other needs they might have upon return? There's also the situation immediately upon return of third country nationals. Will they have access to interpretation? Will they be explained what happened and what will happen next? In some countries, readmitted third country nationals are placed into detention for having established that, yes, they were irregularly migrating and should be placed into removal facilities. So there is quite a lot of concerns and human rights that can be or should be looked into and monitored. What IOM has now recently been doing is that together with the Commission we have been working on a pilot project that should start either the end of this year or early next year. This would be a 3-year pilot project focusing on Ukraine and Pakistan, two countries that were already mentioned as remaining in the focus of particular monitoring. In this project, we will partner with UNHCR, with civil society, to look into what exactly does happen after return. And the idea is to look into third country nationals as well as own nationals, to follow up over 3 years after the return what is happening after, let's say, detention, after readmission, and to, of course, then be able to provide feedback to the host governments, of course, since partnership with them is very important, but also to all other interested parties. And I think I will end here. Thank you very much for your attention.
Thank you. We thank you. We thank you, Madam Schramm, for your contribution. And there we go with the third panelist here this afternoon, Mrs. Hélène Soupios-David, who is the responsible person of Returns, Readmission and Accompanied Children of the European Councils on Refugees and Exiles. Please, there you go.
Thank you. So, as it was mentioned, I'm representing the European Council on Refugees and Exiles, ECRE, which is a pan-European alliance of more than 70 refugee assisting organizations across Europe. And we're very grateful to have the occasion to give our views on readmission agreements here. First of all, I wanted to start by saying that ECRE position on return is that we do not dispute the sovereign right of states both to control who enters their territory and as well to return people if it follows an effective access to asylum procedures for people that would be in need of protection and a fair assessment of the asylum claim and then of the personal situation that would then lead to a return. As it was mentioned before, readmission agreements are often described just as an administrative instrument, a sort of operating tool, which then just facilitates the return itself. So therefore, a readmission agreement is not in itself in violation of human rights. And it's true that there are some human rights safeguards in readmission agreements, but we believe that it's not enough because there are very strong implications related to the actual implementation of those agreements. And this implementation and implication are not always taken into account in the discussions, so I'm very happy that there's this debate today about human rights implication. And the issue in our view is that the neutrality of readmission agreements is based on the premises that the return process is fair and that all safeguards are applied. But unfortunately, we have seen in the past that it is not the case and that there are some violation of human rights happening, there are some concerns. And in the end, we're talking about people, and it's the life of people that can be put at risk in this context. I will not come back to I will try to be complementary to Mr. Cassarino's presentation, who already highlighted a number of human rights concerns. And I wanted to highlight the problems of access to asylum procedures, for example, at the borders and in the context of the application of some concepts in EU asylum law, such as the safe country concepts, safe third country concepts. So, for example, the application of a readmission agreement can be a problem when and if the person in need of protection did not have an effective access to the asylum procedure in Europe. There were cases reported where either an asylum claim was not recorded at the border, where people did not receive proper information of how to claim asylum and their rights in this regard. And it's a particular concern for us in a number of border points at the external borders of the EU. In a recent data collection we did, we have heard of problems at the border of Poland and Belarus, of Hungary with Ukraine and with Serbia, but also, and I guess this is more known, the border of Greece and Turkey. Some organization talking even of pushbacks at the Greek border. And those countries are all countries where either the EU has a readmission agreement in force, so Ukraine and Serbia, or an agreement is in negotiation in the pipeline, such as Belarus and Turkey. So in a report from last year, our member in Hungary, the Hungarian Helsinki Committee, as an example, found that asylum seekers were routinely expelled and deported to Serbia from Hungary without having access to the procedure. And that although the Hungarian police usually states that all expulsion decisions at the border are made in full compliance with legal regulation, the Hungarian Helsinki Committee found that there were cases of unaccompanied children who were expelled without having their individual situation examined. This is also linked to the use of accelerated readmission procedure or accelerated procedures, asylum procedures and admissibility procedures. So at the borders, readmission procedure can be extremely short. And accelerated readmission procedures are included, for example, in EU readmission agreement with Montenegro, Serbia, Russia, Ukraine, as well as in the one that is still not yet in force with Turkey. The problem with accelerated procedure is that means that if you're removed in a couple of days, you may not have access to an effective remedy, you may not have time to appeal, to gather the necessary evidence, to access a lawyer, to access information. So it makes it difficult or impossible to actually appeal a written decision. Also, many readmission agreements allow for the readmission of third country nationals, so we've heard about that. That means readmitting a person that is not a national of the state where it will be returned. And this raises general concerns, especially in the case of transit country. We've heard of Ukraine. And this is related to, as I said, the application of the safe third country concept or first country of asylum, meaning that safe third country concept means that a country which is considered able to offer protection to asylum seekers and that will not put their life at risk, then a person who transited through this country can be sent back there without having their asylum claim examined in the EU member state. So Serbia is usually considered as a safe third country, but as I've mentioned before, a number of NGOs have actually showed that it's not the case. Why? Because in Serbia you have a number of obstacles to actually access an asylum procedure. There is an extremely low recognition rate to 0, depending on the years, and there are actually no effective remedies. So at ECRE we believe that the concept such as a safe country is flawed in itself, and that really undermines the access to asylum of people in need of protection. So if this concept should be used, and readmission therefore linked to that assessment used, it should always be with an individual assessment of the personal circumstances, which, even if it's guaranteed in the law, is not applied in practice. The other problem that has already been mentioned by Mr. Cassarino is the problems of human rights violation in third countries themselves and the risk of what we call chain refoulement, so send back, expelled from one country to another, where at the end the life of the person may be at risk or their freedom and rights may be at risk. There have been cases documented, and this can have irreparable consequences on the life of people. We have heard about people being detained upon return, so in Ukraine and Morocco. I will not come back to that. Just to mention that in Ukraine, unaccompanied children can also be detained in the same condition as adults for having crossing a border illegally. There is no access to the asylum procedure in a number of states, as I have said. And, for example, there's no proper asylum system in a number of countries. That Ukraine does not have a proper system, and UNHCR urges in a recent report of July 2013, a position UNHCR urges states not to return asylum seekers to Ukraine on the basis that they could, on the safe third country basis. Also, if we think about the negotiations with Turkey, an agreement was being negotiated and agreed while Turkey was not having an effective system in place and was applying a sort of what is called a geographical limitation, meaning that most asylum seekers were not eligible for status in Turkey except through a UNHCR procedure. Turkey did adopt a new law that has a lot of positive aspects, but it's not fully implemented, and even when it's implemented, it will need to be assessed. And then, so if you return third country nationals to a transit country, a country that is not their own, that means that if they cannot have access to asylum because of the issues I've just mentioned, then there is a risk that they will then be expelled, readmitted to their countries of origin. We could think of a Russian national, but from Chechnya, that would be readmitted to Ukraine, and that then Ukraine would send back to Russia. This is also the case to Serbia, who then readmits people to Montenegro or to Greece. So, as Jean-Pierre Cassarino mentioned, we agree that the EU should always consider as a primary criterion the respect of human rights when deciding with which country to negotiate readmission agreements. And for those who are in force, we believe there should be a sort of suspension mechanism that would suspend the application of a readmission agreement when there is a proof of human rights violation of the readmitted people. So there is a number of reports of this human rights violation, but unfortunately there is probably more that we don't know because there is very few monitoring and it's largely unreported. So monitoring has already been mentioned. I'm not going to talk a lot more on that. I just wanted to say that we really fully advocate for an effective and independent monitoring. There's a real need of transparency around this monitoring, and we really hope that this pilot project that IOM is going to do will be a transparent project with transparent findings, that civil society will be indeed involved, and that this will not just be a pilot project, but that it will actually be a more effective and efficient and systematic. So in conclusion, I think reports of human rights violation that exist should be taken into consideration when the EU and member states both negotiate and assess readmission agreements. There was a lot of good recommendation in the European Commission evaluation of EU readmission agreement that was published in 2011. But then in the subsequent Council conclusion, very few of those recommendations were taken forwards. I think there's this need of transparency is also important in that regard, to know what happens with this recommendation, what happens next. As I said, return can have irreparable consequences for the life of the people returned, and people should never be sent back to places where their life are at risk or their freedom is at risk. The responsibility of member states does not stop at their border, and this is also, I think, one of the roles of the European Parliament, to remind member states of this and to play an active role in ensuring that there is efficient monitoring. Thank you.
Thank you, Mrs. Soupios-David. And now, for a first exchange of views, I understand the desk officer of the EEAS information has not made it for the meeting, but we have the European Commission's representative of the DG Home, Mrs. Niels Coleman. No, Mr. Niels Coleman.
I left Mrs. Coleman at home, but if you don't mind, I'm happy to take the floor. Thank you very much for this opportunity to react. My name is Niels Coleman. I indeed work at DG Home, where I'm part of a two-man team which is in charge of negotiating and monitoring the implementation of the EU's readmission agreements. Glad to be able to react today. The Commission services would, of course, have been more than ready to give a presentation today had we been invited to give you a more detailed account of our policies in this area, which have developed strongly since, in particular, the debate, I think, with the European Parliament surrounding the readmission agreement with Pakistan. But I will do my best, certainly, to give you a quick overview now. The Commission takes very seriously the potential impact of the EU readmission policy on human rights protection. This you will see outlined in significant detail in a 2011 evaluation that the Commission produced, which was a Commission communication, which also made a number of very important recommendations. The legal framework of readmission and human rights protection, I think, is very clear. It's important to stress that readmission agreements do not exonerate in any way the contracting parties from adhering to their international obligations. Quite on the contrary, EU readmission agreements reiterate the application of those international obligations, such as those following from the Geneva Refugee Convention or indeed the European Convention of Human Rights. Readmission agreements cannot be applied to anyone who is at risk of refoulement, be it direct or indirect, or anyone at risk of infringement of other rights which would prevent expulsion. Indeed, the EU Asylum Acquis, also the Return Directive and all its safeguards apply in full to individuals who are subject to readmission as a result of a readmission agreement. The Commission, of course, does recognise that there can be a difference between the legal framework on the one hand and practice or implementation on the other, which is why in the 2011 evaluation that I just mentioned, the Commission made a number of recommendations for introducing certain flanking measures or additional safeguards in this regard. Some of these flanking measures you will see incorporated in the latest readmission agreements that we have negotiated. LIBE recently voted favourably for giving its consent to the conclusion of the readmission agreement with Armenia, which I believe the plenary will be voting on the 9th of October. This is the first readmission agreement of the EU that you will see that has new provisions that are relevant in this regard. It has an additional article which ensures the respect of the contracting parties of human rights protection during the readmission procedure, in particular of the receiving country after readmission has taken place. It contains a provision which gives priority to voluntary return, and importantly it contains, or it introduces, a new element in EU readmission agreements, which is the possibility to suspend the agreement in appropriate cases or when there is a necessity to do so. In addition, the Commission is piloting monitoring along the project that IOM just outlined. We are hopeful and that this project will be up and running soon. It will be implemented in Ukraine and Pakistan, as was already mentioned. It will run during 3 years. Our intention is indeed for this to be a very transparent project involving fully civil society as well as IOM and UNHCR. After the 3 years running time, the Commission, of course, will draw appropriate conclusions as to the practicality and feasibility of monitoring, also possibly on a broader scale. This version of monitoring, of course, comes in addition to the monitoring that already takes place within the scope of the joint readmission committees that each of the EU's readmission agreements has put in place. Perhaps just a quick final word on the readmission of third country nationals, i.e. non-nationals of either of the contracting parties to a readmission agreement. This has been for a long time, I think, one of the main concerns in terms of human rights protection. Here it's perhaps important to note that practice indicates that this particular obligation in EU readmission agreements is used very rarely. It's quite clear that member states prioritize return to countries of origin as much as possible. There is some application at the external border within the accelerated procedures. Here there are some numbers, but they are limited. I should also add that the statistics that the Commission has are sketchy. This is something that needs to improve. Here the Commission has also made several recommendations, and we do hope that this can improve in the near future. We need a more complete picture, especially in relation to readmission in general, but especially in relation to third country nationals. We need, let's say, more quantitative and qualitative data, which would indeed be very useful in discussions such as the one we're having today. Thank you, Chair.
We thank you for that contribution. Now the room is open for further discussion. Members willing to make points. Of course, Co-Chair Lochbihler will be having the concluding remarks. If you want to make some statement now or some question, of course.
Okay.
Of course.
Thank you. You know, we in the DROI committee, we don't have very often this on our agenda, and I'm not an expert on it. So I have questions to you all. And first, let me say, I also very strongly regret that nobody from the EIS is here, because we have invited them in time. And as Professor Cassarino said, it would make some added value if the EIS also focus on this work, particularly, so you said, on North Africa. Now, I have also questions to you, and I hope my questions are appropriate, as I'm not an expert on this. You said there is a joint readmission committee who deals with technical issues. And and now I heard from you and from all the speakers, there is a need to do a lot of more independent monitoring. So what is your judgment then? How should this monitoring look like in this joint readmission committee? Do you think it is already working, or does it need more, let's say, independent reports? I don't want to make prejudgments, but I think learning from the past that only when there were clear documentation, independent NGO documentation of what happened to people when they have been sent back, then the European system, if I may say so, reacted. Very prominently in my memory stays the case of Hirsi versus Italy on the European Court for Human Rights, where people have been sent back to Gaddafi Libya, faced torture, and all was, maybe the paperwork was done, but only with the help of NGOs and their braveness, actually. They turned to the court in Strasbourg and got some good decisions, I would say. And so and we heard this also from DG there are some flanking safeguards now to make this legal framework also more practical, but it would be good from you to hear also what you think, how could we improve the monitoring. The same goes also, and then you said that Serbia is not a safe country. So our DROI delegation sends a delegation to Serbia on all human rights issues in Serbia, and maybe we should also look into this issue as well, how the situation, for example, with asylum procedures or asylum law in Serbia is progressing or not. You said that the criteria for readmission needs to be reviewed. Did I understand that right?
They have to be, let's say, updated.
Updated. And if
they were defined in 2002 already.
Okay.
But nowadays, after Lisbon, it's time to change.
Okay, good. So that is because of this. Now to Madam Schramm, also regarding the monitoring. You spoke about the pilot projects you're planning to do. Do you have already existing cases where people went to the court because they faced human rights violations after they have been sent back to a third country or to their home country? Maybe you just collect the questions because I see more colleagues have one. And to ECRE, you were arguing for a stronger human rights safeguards in the readmission agreements, and you mentioned that there should be a good asylum laws and procedures in the relevant country, and you also referred to the monitoring mechanisms. Do you have further criteria? For example, what cases should lead to the suspension of readmission agreements? Because now I hear also from DG it's a possibility, but in what cases, what kind of country situations do we need to be able to have suspension of agreements? I think that's from my side. Thank you.
Thank you. And I suggest, just to order the second round for replies and responses or reactions to the comments or specific points that we've just heard from Mrs. Lochbihler, I suggest we give the floor also to Senora Romero Lopez. You were also willing to make some point, and if there is some other member in the room willing, please let us know. Just raise your hand so that we can gather the questions and then the answers. Please, Senora Romero Lopez.
Sí, gracias, presidente. Yo querría, dar las gracias a los ponentes por la posibilidad de la información que nos dan sobre estos acuerdos de readmisión y también, como está aquí la Comisión, si pudiéramos conocer más a fondo algunas de las circunstancias en las que se está haciendo poniendo en práctica la directiva de retorno, porque efectivamente la directiva de retorno se puede haber traspuesto en los distintos países de manera diferente. Y bueno, los periodos de internamiento, las condiciones de internamiento, etcétera, etcétera, son diferentes en los distintos países de la Unión Europea. De todas maneras, el estudio de 2011 de la Comisión acerca de que habría que reconsiderar algunos aspectos de estos acuerdos de readmisión y también algunos de los que están en esta directiva de retorno, pues nos hacen pensar que efectivamente esta disparidad de situaciones no es concebible en una Unión Europea. Entonces, yo quisiera preguntarle aquí ahora a los que están participando y también a la Comisión a qué se debe estas diferencias tan enormes de periodos en los centros de detención y en los periodos de internamiento para aquellos que solicitan asilo o incluso para los inmigrantes ilegales, y a que no haya tampoco mucha intervención judicial para denunciar las ilegalidades flagrantes que se están dando en algunos países. Si tienen ustedes información o si los parlamentarios podríamos tener información de eso para denunciar esas situaciones y poder avanzar en un trato más humanitario a quienes no han cometido delitos, sino simplemente a lo sumo son faltas administrativas, pues porque han entrado irregularmente.
Okay. Any other? Yes, please. Mr. Okan. Go on.
Thank you very much, Mr. Chairman. I would like to put the panelists a very amateurish question. Madam Chair put it in a very logical way, but still. I was intrigued by the statement of two of you who said that Serbia is not a safe country. Oh boy. How does it, whether you can explain it in a very practical term? As we all know, some 2 years ago, countries of the Western Balkans got the visa-free regime to visit the Schengen area. Was it okay if it is not a safe country? Can the Serbians ask for the political asylum? I don't think so. So please, if you can enlighten me on that. Thank you.
If no further points, some question was made to the Commission's representative and then back to the podium. Maybe Mr. Coleman, would you like to address the point that was raised by Senora Romero Lopez?
Not being an expert myself on the return directive, I'm very happy to pass the floor to my colleague Manfred Hélène.
Good afternoon, everybody. I took from your question that you wonder why there are why the rules and procedures on concerning return are not fully harmonized and are not the same in each and every member state. But this is exactly the spirit or the rule, the existing rule of the return directive, that there are margins. For the detention, for the question of detention, we have very clear conditions and rules, and it was hard, the negotiations were very hard to get these safeguards into the existing rules, and member states have to accept and had to accept that detention, for example, is the measure of last resort. So, that we have not yet fully harmonized systems and periods for detention may be not fully satisfying for everybody, but actually what we have achieved with the return directive is already a good step into the right direction. The assessment of the transposition of the return directive in member states is currently ongoing, and as guardian of the treaties we are looking very, very seriously into details of transposition, and if there are justified cases to ask inconvenient questions, we will do that.
Now let's get back to the podium, because some questions were put by our colleague, Mr. Lochbihler, and I think there is some ground for a second round, and then concluding remarks. We get started the same way, Professor Cassarino, or maybe you, as you please. Mrs. Schramm, would you like to go first, please?
Thank you very much. I would like to try to reply two of your questions, Mrs. Lochbihler. The first one regarding what more could the joint readmission committees do, and why is the monitoring more technical than human rights oriented. I think the joint readmission committees, they are more the bilateral or multilateral level, but between the EU and the readmitting country. So per se they cannot be independent, because it's the two parties who see how well they have been doing. And therefore I think there's a need for international organizations, civil society, to supplement this monitoring of, at the technical level, how fast do we get a reply when we send a request, how fast is the return then realized. There needs to be someone who looks into what happens to the persons afterwards, etc. And this is where I would like to come to your second question. You asked whether we have examples of monitoring that was done and where problems with regards to human rights were identified. Well, in fact, I do work in Ukraine, and together with UNHCR and ECRE, we developed a tool some years ago. It's called the Observatory Mechanism, and it consists of monitoring access to rights and services of migrants who are in detention facilities, including those who have been readmitted from the European Union. So on the one hand, what we saw is, and that's probably more for ECRE to talk about, is that some people claimed that they tried to apply for asylum in a European Union member state and were not given the chance, whilst Ukraine considered that since they had a chance in the European Union, why would they let them access the procedure? But on the other hand, we also looked together into much more, let me say, basic rights, not connected even to asylum, but the right to have legal counseling, an interpreter, understand what is going on, representation in court, on, for example, the removal hearing in Ukraine. And I think that through this tool that did provide information, and through following constructive dialogue, we did achieve quite a lot. And now, for example, NGOs can have access to detention facilities to provide legal counseling and representation at any moment. So I don't know if I replied to your questions, but thank you.
Okay.
So I reply accordingly to all the questions, if I may. Regarding the joint readmission committee, each European readmission agreement has its own joint readmission committee, which gathers together, let's say, clearly, stakeholders from the third country concerned, the one who is party to the European readmission agreement, clearly people from the staff from the European Commission, and also members from staff from the EU member states, those who are involved, let's say, in the bilateral cooperation. What has to be borne in mind is that not all EU member states cooperate at a bilateral level with a third country which concluded an EU readmission agreement on the basis of an implementing protocol. I would say perhaps it might be too provoking, but it's not a sine qua non condition. You may cooperate in the framework of an EU readmission agreement as long as the cooperation is compatible with the terms of the European readmission agreement. Some member states do not have an implementing protocol, and this is a big issue, because once you have an implementing protocol, normally you, let's say, disclose, let's say, the terms of your own cooperation. You know, everything is let's say, cleared up to some extent, which is not always the case. And this is a big issue in the monitoring also of the implementation of the EU readmission agreements. This is one point. I would like to make clear also another aspect in a post-Lisbon context. Well, the European Parliament's empowered position with regard to the Council also through the ordinary legislative procedure. In my opinion, the European Parliament has a key role in, let's say, well, in the monitoring operations, the Joint Readmission Committee. This is an issue which I mentioned in the report which I wrote for the European Parliament in 2010. I hope that one day it will be factored, because in my opinion it is provoking, but at the same time it is extremely necessary in a post-Lisbon context. And the other issue regards the criteria which are used, in order to identify third countries with which European readmission agreements can or should be concluded. Also, the European Parliament should have a say, regarding these clear criteria. I think I replied to your questions, right? Serbia. No, Serbia is not, a safe third country. If I refer to the report which was produced by the UNHCR last year in 2012, I believe that the, let's say, the evaluations and reports which are produced by the UNHCR are, let's say, serious reports which allow policymakers, decision makers, to have a better light on their own decision. I would like also to make clear that there is already in one directive of the European Union, which is the one which regards the directive of 2005 on the procedure for granting or not granting the status of refugees, which is Article 27, which defines clearly the concept of what is a safe third country. If you wish, I can also send to you this document just for you to have a clear idea of all the criteria, which are extremely clearly. Thank you.
Okay, thank you. And maybe you, Mrs. Soupios-David?
Yeah. So on the first question was on the suspension clause. Well, first, I think it's really important, and it was also some of the recommendations that were put forward from the Commission. If you already have not only a safeguard in an agreement that just says human rights should be respected, but that you actually list all the conventions and texts that states are parties to and that their rights that should be respected, that's already something that is an improvement. Indeed, the assessment on an effective asylum system in the country where people are readmitted. So we've heard now that it's not really the case in Ukraine or in Serbia or in Pakistan, for example, or in Turkey. And a suspension clause, what would trigger it? Well, a report of violation of human rights. Arbitrary detention is a violation of human rights. If people are systematically detained upon return with no review of their detention for prolonged period in bad condition, this is a violation of their rights. It's a breach of the European Convention on Human Rights. If they are badly treated, it's, if conditions in the state are so bad that they're a victim of ill treatment, you can refer here, think, for example, of the case of MSS versus Belgium and Greece, where the court said what would constitute ill treatment by a return to Greece. So this is within Europe, but that's already set some indication of what, homelessness in the institution could amount to ill treatment to a certain extent, if in a particular case. So if those cases are reported, then I think agreements should be suspended. So if there are recent reports that Ukraine does not respect the rights of third country nationals, then there should not be a readmission agreement. The readmission agreement should not be applied to those third country nationals. And I wanted just to come back on the issue of a safe country. We're of course talking here a sort of legal term, but no, Serbia is not a safe country for asylum seekers. It might not be a safe country for their own nationals. Serbians do apply for asylum, some for because they are actually in need of protection, because they are persecuted in their own state. It does happen. I just wanted to remind you that in the first Asylum Procedures Directive, it included the idea that the European Union should come with a common list of safe country of origin, and they actually never managed to agree on that list. So what is a safe country is actually something that even EU member states do not agree on, and Serbia and other countries are not. There's not as such a safe country. It always depends on the individual. And I was, on this return to Serbia, I thought of, we recently published a report and put online a website called the Asylum Information Database, on which we have testimonies of refugees and asylum seekers. And there's this story from an Afghan woman who is now in Hungary, who actually got protection in Hungary, who was sent back through an accelerated procedure to Serbia at the border in the middle of winter, just kind of put on the other side of the border in the snow, while she's quite young, and she managed to come back to Hungary and finally got her claim for asylum recorded and did get the status. So it is happening, and in Serbia she could not have access to asylum procedures and be protected there.
Thank you. If no further hands have been raised, I don't see any other members or people in the floor, representative of the organizations or whatever interest might be present in the hall. If not the case, I think this is about it. We're coming to the concluding remarks of this working session we've had so far. We thank all of the contributions, of course. We have the three panelists that we've just heard, and co-chair Lochbihler, if you want to conclude, that'll be a pleasure.
Thank you. And I can conclude with a nice quote, actually, I just found, and it's also good that we do this hearing, or we did this hearing together. I think for the Human Rights Committee, I think I take a note and will see to hear from the IOM what you found in the future from your pilot projects. But as I said at the beginning, we did a DROI opinion to the midterm review of the Stockholm program you referred to at the beginning. It was done by our colleague Jean-Jacques Bissep. And what does it say on this joint readmission committees you also referred to, Professor Cassarino? We call on the Commission to allow not only the Parliament but also NGOs, international organizations, European Parliament representatives to participate in the joint readmission committees and to urge the Commission to give Parliament access to the documents prepared by this committee. So we hope that the LIBE committee, and of course on a committee, but also the majority of the political parties here agree on such a recommendation, then it would certainly help to improve the work of these joint readmission committees. Because just what we hear, the case you gave at the beginning, at the end, very often I think this kind of policies dealing with refugees and people being sent back are very scandalous driven. That you get the majority of the political parties only to change policy after a very scandalous event. Or this, how can I say, if a refugee or a migrant who has been sent back is lucky enough to find somebody to support him and then makes the case again. Unfortunately, we have not so strong, in my personal opinion, human rights-driven refugee policy. So, and I thank you again also for coming, and thank you again for having a joint meeting. Thank you.
Absolutely. It's been a real pleasure, a privilege. We thank you all. That'll be it. Thank you.
So those colleagues from DROI, I have to remind you that tomorrow we meet in a different room, starting with the hearing on Iran. We meet in RSP 3G3 at 9. Thank you.
Würden Sie so nett sein, Ihr Autograph zu geben? Das ist Mr. Schulz for the Serbian Justice Official. And at the front too, please. Thank you. Mm-hmm. I think that will stay.
Oh, so thank you. Really, it's a pleasure. But you see, unfortunately, our members who are also LIBE members, they were not here, so they could have asked more. Always with some.